If you hold dual citizenship or you're thinking about obtaining a second passport, stop everything and listen right now. February 2026 just brought the most dramatic changes to dual citizenship laws in American history. And what I'm about to reveal could completely change your legal status, your tax obligations, and your ability to travel freely between countries. We're talking about new reporting requirements, unexpected tax consequences, passport restrictions, and penalties that could cost you tens of thousands of dollars or even result in citizenship revocation. This isn't speculation. These laws are active right now, and dual citizens across America are already facing serious consequences because they didn't know what changed. Whether you were born with dual citizenship, obtained it through marriage, or acquired it through naturalization in another country, these new rules affect you and you cannot afford to ignore them. Welcome back, and thank you for being here. I'm bringing you an urgent alert today that affects an estimated 9 million Americans who hold dual citizenship, plus millions more who are considering obtaining citizenship in another country. The Dual Citizenship Transparency and Accountability Act that went into effect in February 2026 has fundamentally changed the rules of the game, and the vast majority of dual citizens have absolutely no idea what's coming. In this video, I'm going to break down every single change, explain exactly who's affected, reveal the specific penalties you could face for noncompliance, and give you a detailed action plan to protect yourself starting today. This is comprehensive. This is critical, and this could save you from legal nightmares you never saw coming. Let's dive deep into these game-changing laws. Let me start by telling you about Jennifer, a 42-year-old American citizen living in California. Jennifer was born in the United States to an Italian mother, which automatically gave her Italian citizenship at birth under Italian law. She's lived her entire life in America, always considered herself American, and honestly never thought much about her dual citizenship status. In late February 2026, Jennifer received a certified letter from the Department of State informing her that she had 30 days to comply with the new dual citizenship reporting requirements or face penalties, including passport suspension and fines up to $10,000. Jennifer had no idea these new laws existed. She scrambled to comply, hired an attorney, and barely met the deadline. But thousands of dual citizens, just like Jennifer, are missing these deadlines entirely because they simply don't know about these changes. So, what exactly is the Dual Citizenship Transparency and Accountability Act? And why did Congress pass such sweeping legislation? According to lawmakers, the purpose of this new law is threefold. First, to track potential conflicts of interest for dual citizens working in sensitive government positions. Second, to prevent tax evasion and ensure compliance with U.S. tax obligations. And third, to enhance national security by monitoring citizens with allegiances to multiple countries. Whether you agree with these justifications or not, the law is here, it's being enforced, and understanding it is absolutely essential. The first and most immediate change is the new mandatory dual citizenship registry. Every U.S. citizen who holds citizenship in any other country must now register with the Department of State using a new form called the DS-4600, the Dual Citizenship Declaration Form. This requirement applies regardless of how you obtained your second citizenship, whether you were born with it, inherited it from parents, obtained it through marriage, acquired it through naturalization, or received it through investment programs. Here's what makes this so urgent. If you already had dual citizenship as of February 1st, 2026, you have until May 1st, 2026 to file this declaration. That's a 90-day window, and we're already well into it. If you're watching this video right now, you need to act immediately because that deadline is approaching fast. For anyone who obtains dual citizenship after February 1st, 2026, you have 60 days from the date you acquired the second citizenship to file the declaration. What happens if you miss the deadline? The penalties are severe. First-time failure to register results in an automatic $1,000 fine. Second or subsequent failures can result in fines up to $10,000. Additionally, your U.S. passport can be suspended, which means you cannot travel internationally until you comply. In extreme cases of willful failure to register, you could face federal charges for providing false information to the government if you've ever checked a box stating you don't hold other citizenships. The DS-4600 form itself is extensive. You must list every country where you hold citizenship, your passport numbers from each country, when and how you obtained each citizenship, whether you've served in a foreign military, whether you hold or have held government positions in any foreign country, and whether you own property or have business interests in countries where you hold citizenship. This is comprehensive disclosure, and the State Department is actively cross referencing this information with databases from the IRS, Department of Defense, and intelligence agencies. The second major change involves enhanced tax reporting requirements for dual citizens. The IRS has always required U.S. citizens to report worldwide income regardless of where they live or what other citizenships they hold. That hasn't changed. But what's new in 2026 is the mandatory disclosure of all foreign financial accounts, investments, and assets above much lower thresholds than before. Previously, the threshold for filing an FBRR, the Foreign Bank Account Report, was $10,000 in aggregate foreign accounts. Under the new law, dual citizens must now report any foreign account with a balance exceeding $5,000 at any point during the year. Additionally, there's a new form called FinCEN Form 115, the Dual Citizen Asset Disclosure, which requires you to report ownership interests in foreign businesses, real estate holdings abroad, and certain foreign trusts or investment vehicles. The penalties for failure to file these forms are astronomical. Non-willful failure can result in penalties up to $10,000 per violation per year. Willful failure can result in penalties of up to 50% of the account balance or $100,000, whichever is greater. And these penalties can be assessed for each year you failed to file, meaning they can accumulate into the hundreds of thousands or even millions of dollars. I've already heard from dual citizens who had no idea they needed to report a modest savings account in their parents' home country or a small investment property they inherited. These aren't wealthy tax evaders. These are ordinary, hardworking people who are now facing catastrophic penalties simply because they didn't understand the new reporting requirements. The third significant change affects dual citizens' ability to hold security clearances and work in certain government positions. The new law establishes different tiers of restrictions based on which countries you hold citizenship in. Countries are now classified into three categories: Tier 1 Allied Nations, Tier 2 Neutral Nations, and Tier 3 Restricted Nations. If you hold citizenship in a Tier 1 country, which includes nations like the United Kingdom, Canada, Australia, Germany, France, Japan, and most NATO allies, you can still obtain and maintain security clearances, but you'll face enhanced scrutiny and more frequent reinvestigations. If you hold citizenship in a Tier 2 country, you may be restricted from certain high-level clearances and positions involving access to classified information. If you hold citizenship in a Tier 3 country, which includes nations with adversarial relationships with the United States or countries flagged for security concerns, you may be completely barred from security clearances and certain government positions, and you could be required to renounce your foreign citizenship to maintain your government employment. This is already causing serious disruption for thousands of government employees, military personnel, and defense contractors who suddenly find their careers in jeopardy because of citizenship they've held their entire lives. Some are being forced to choose between their heritage and their livelihoods, and it's creating enormous personal and professional turmoil that no one anticipated. The fourth major change involves new restrictions on dual citizens running for federal elected office. Under the new law, anyone seeking election to the U.S. House of Representatives, Senate, or the presidency must renounce all foreign citizenships before filing to run for office. This is being challenged in courts on constitutional grounds, but for now, it is the law. If you hold dual citizenship and have political ambitions, you need to understand that you'll be required to give up your other citizenship before you can even become a candidate for federal office. The fifth change affects military service. Dual citizens can still serve in the U.S. military, but there are significant new restrictions. If you hold citizenship in a Tier 3 country, you're now barred from military service entirely. If you hold citizenship in a Tier 2 country, you can serve, but you're restricted from certain military occupational specialties, particularly those involving intelligence, cybersecurity, or access to sensitive information. Even dual citizens from Tier 1 countries face additional background investigations and periodic reviews throughout their military careers. Furthermore, any dual citizen who has ever served in a foreign military must now report this to the Department of Defense within 30 days. even if that service occurred decades ago. Failure to report can result in dishonorable discharge for active military members or loss of veteran benefits for those already separated from service. This is not a technicality. Enforcement is active. Let's talk about passport and travel implications, because this is where dual citizens are experiencing the most immediate practical impacts. The new law requires dual citizens to declare all passports they hold when entering or leaving the United States. At every border crossing, customs officers are now asking specifically, do you hold citizenship in any country other than the United States? If you answer no, and they later discover you do, you can be charged with making false statements to a federal officer, which is a serious federal crime. Additionally, if you're registered in the dual citizenship registry and you obtain a new passport from your other country of citizenship, you must update your DS 4600 form within 30 days. This means every time you renew a foreign passport, you have new reporting obligations to the U.S. government. Many dual citizens are not aware of this ongoing requirement, and that lack of awareness is already creating compliance violations. There's also a new exit tax consideration that's catching many dual citizens completely by surprise. If you're considering renouncing your U.S. citizenship while retaining your other citizenship, the exit tax rules have become far more aggressive. The IRS now presumes that anyone renouncing U.S. citizenship is doing so for tax avoidance purposes, unless you can affirmatively prove otherwise. The burden of proof has shifted entirely onto you. The sixth change involves restrictions on certain dual citizens receiving security-sensitive federal benefits. If you hold dual citizenship with a Tier 3 country, you may now be restricted from participating in certain federal programs, including some research grants, certain small business administration programs, and specific federal contracts. This is particularly impacting academic researchers and small business owners who never imagined their citizenship status would affect their eligibility for federal funding or contracting opportunities. The seventh major change is the new requirement for dual citizens to notify the State Department if they accept any position, employment, or title from a foreign government. This includes not just elected positions or military service, but also appointments to government boards, commissions, advisory roles, or even ceremonial titles. If you accept any such position without first obtaining written approval from the State Department, you could face citizenship revocation proceedings. There are cases right now of dual citizens who accepted honorary advisory roles in their countries of origin and are now facing potential loss of their U.S. citizenship because they didn't obtain pre-approval. This is not theoretical. It is happening. The eighth change involves enhanced vetting for dual citizens applying for certain professional licenses. Some states are now requiring disclosure of dual citizenship status when applying for licenses in fields like law, medicine, nursing, engineering, and teaching. While states can't outright deny licenses based solely on dual citizenship, that would likely be unconstitutional, they can conduct additional background checks and require more extensive documentation from dual citizens, creating delays and complications in the licensing process. Now, let's discuss the new annual certification requirement for dual citizens in certain categories. If you work for the federal government, hold a security clearance, work as a government contractor in sensitive positions, or work in certain regulated industries like defense, aerospace, or nuclear energy, you must now file an annual certification confirming your dual citizenship status, declaring that you have no conflicts of interest, and affirming that your primary allegiance is to the United States. This annual certification is filed using Form A-109, the Dual Citizenship Annual Affirmation. Failure to file can result in loss of clearances, termination of employment, or contract cancellation. And here's the reality. Many employers aren't yet informing their employees about this requirement because they're still figuring out how to implement these new rules internally. Let me give you specific, actionable steps you must take right now to ensure compliance with these new laws. First and most urgently, if you hold dual citizenship, go to the State Department website immediately and download Form DS 4600. Fill it out completely and accurately, gather all required documentation, including copies of all your passports and documentation of how you obtained each citizenship, and submit before the May 1st, 2026 deadline. Second, schedule a consultation with a tax attorney or CPA who specializes in international tax compliance. Review all your foreign accounts, assets, and income sources to determine your full reporting obligations. If you failed to file FBARs in previous years, you may be eligible for the IRS streamlined filing compliance procedures, but you need expert guidance to navigate this correctly. Third, create a comprehensive inventory of all your connections to your other country of citizenship: property, bank accounts, business interests, government positions held, military service, and any other ties. Having this organized in advance will make every compliance step significantly easier. Fourth, if you have children with dual citizenship, ensure you've properly registered their status and that you understand their ongoing obligations as they grow up. Many parents are discovering that citizenship they thought was purely an advantage for their children is now creating compliance burdens that could follow them for life. Fifth, if you're in any sensitive category, government employment, security clearance, military service, defense contracting, contact your HR department or security office immediately. Don't wait for them to come to you. The penalties for noncompliance are too severe to take that risk. Sixth, review your travel patterns and make sure you're prepared to accurately answer questions about your dual citizenship status every single time you cross a U.S. border. Never omit or misrepresent your citizenship status, as this can result in criminal charges. Seventh, if you're considering renouncing either your U.S. citizenship or your foreign citizenship, consult with both an immigration attorney and a tax professional before making any decisions. Renunciation has enormous legal, financial, and deeply personal consequences that must be carefully weighed. Here's the absolute truth that every dual citizen in America needs to understand. February 2026 marked a fundamental shift in how the United States government views and regulates dual citizenship. These laws are real. They're being enforced right now. And the consequences for noncompliance range from financial penalties to loss of employment to potential citizenship revocation. This is not a time to put your head in the sand and hope these requirements don't apply to you or that enforcement will be lax. The government is serious. They have the technology and the databases to identify noncompliance, and they are actively pursuing penalties against those who fail to meet these new obligations. Your dual citizenship may represent your heritage, your family history, your connection to another culture, or simply a practical benefit you were born with or acquired through life circumstances. Whatever it means to you personally, protecting it and staying compliant with U.S. law requires immediate action and ongoing diligence. Don't lose your rights. Don't face devastating penalties. And don't jeopardize your future because you simply didn't know about these changes. If this video helped you understand the February 2026 dual citizenship law changes, please smash that like button and share this with every dual citizen you know. This information is too important to keep to yourself. Your friends, family members, and colleagues who hold dual citizenship need to know about these requirements immediately. Subscribe so you never miss critical updates about citizenship laws, immigration changes, and legal requirements that affect you directly. Drop a comment below telling us if you hold dual citizenship, which countries you're connected to, and whether you have questions about how these new laws apply to your specific situation. We read every single comment, and your questions help shape the content we create to address your real concerns. Remember, your citizenship status is fundamental to your identity and your legal rights. Protect it, stay compliant, and stay informed. The May 1st deadline for dual citizenship registration is approaching fast. Don't delay. Take action today. Until next time. Stay informed, stay compliant, and remember, knowledge is your best protection in these changing legal times. Take care and act now to protect your dual citizenship status.